All right, we are now recording. Thank you to those who showed up and to those who were unable to attend. I'm recording this and we will get this out to you as soon as possible. I'm going to share my screen momentarily. Okay, so welcome to the note/comment training. Dan is currently driving, but he will be able to answer any questions that you may have. Once he parks, he'll be able to unmute. So for now, it's just going to be hosted by me. So the first thing is really what is the note/comment. So it is one of your requirements as a staff editor. It's one of the two core writing requirements that you have to maintain as a member of the journal. So the first being the note or comment, the second being the blog post, which you will complete in your spring semester. More to come on that in the future. Don't worry about that for now. For right now, we're just focusing on the note and comment. Just wanted to put that on your radar. It's an opportunity to receive a course credit, as I kind of discussed with all of you over the summer. If you did not elect to take the note credit in the fall or right now, you're able to receive it in the spring if you would like. That's something that you'll communicate with Rose Callahan, who is our secretary for all of the honor societies here at the law school. So that's kind of not really in my hands, but I'm happy to answer any questions that you may have if there's anything lingering about being able to receive course credit. The other big thing about the note and comment is that it's a chance for publication. Typically, 2 student notes are selected for publication, but this year, depending on a variety of different factors, we may select more. I think probably the minimum that we will select is 2, so long as there's at least 2 publication worthy papers. And I see Dan is giving me the thumbs up on that. But depending again on a variety of factors, it's possible that more than 2 may be published. So that's just something to keep in mind as well. And really the note and comment is kind of an opportunity for you to really take a deep dive into a particular topic, something that you're really interested in. And it really kind of makes you, I mean, not an expert, of course, but it really kind of gives you a leg up on other folks who may not have as much knowledge in that particular topic. So it's a really great way for you to hone in on your legal research and writing skills and really have that opportunity to potentially be published. So I think a lot of people kind of confuse what a note is versus what a comment is. So comments are typically more broad. They're either a statement or an analysis on a specific topic or area of the law. You can make an argument for or against a certain aspect. So for example, if there's, something is currently the law and you're making an argument that it shouldn't be, that would fall under the realm of a comment. And a lot of times folks will focus really on public policy implications because oftentimes the law can, it's black letter and it's hard to get around it. But when you're able to kind of look into those public policy implications, particularly being in the state of Delaware and having those separate courts of law and equity, it's really interesting to kind of look into the public policy and see what your topic can offer in that regard. And it's really, you can kind of think of it as condensing an area of the law into a more readable format. So for example, if somebody's topic was, the Second Amendment, there's so much case law, there's so much research, so many things that have been done on the Second Amendment, and being able to kind of condense a lot of it or one certain aspect of it and really do a deep dive on that one specific point allows for readers who may not have the most diverse background in that area of the law really be able to understand it. Then on the alternative, case notes are typically more specific, more narrow. And these are your analyses on a specific case. So for example, if you were looking at, a big recent Supreme Court case like EPA, we'll take for example, and you would be commenting on the case itself, kind of what the court was looking at. And then you can also utilize assessing its implications. So talking about, is this a slippery slope in your opinion? And is this going to have, big downfalls and big impacts on the way that the courts are active in the future, or is this going to have positive implications? You can talk about like trends, circuit splits, bringing in other case law. And it's really, these are not rigid. It's just kind of to help you understand what is the difference between a note and a comment. And I just want to point out, you're only mandated to do one, whether it's a note or a comment. You're not doing a note and a comment. Just want to, in case there was any confusion on that. And then just something to keep in mind is that We are the Delaware Journal of Corporate Law. So if you're looking to get published in the Delaware Journal of Corporate Law, it's not impossible to get published if you're not related to Delaware itself. But at the end of the day, we do kind of cater towards our subscribers, and a lot of them do subscribe because they're interested in Delaware corporate law. So keep that in mind. That is something that we will certainly take into consideration when we're selecting folks for publication, because we do cater to the state of Delaware. Any questions so far? Great. And feel free to interrupt me or utilize the chat feature if there's anything as well. So you may kind of be asking yourself, all right, I picked my topic, it got approved, now what? So I do just want to point out that every single one of you has now had an approved topic, which is great. But as you begin to kind of conduct your research, you might change your course, and that's totally fine. If you told me that you were going to do something related to circles, and as you're doing your research, you're like, oh, rectangles, it kind of seems like it's more fit. Of course, that won't be your actual topic, but just to kind of provide some kind of a basis as to what I'm getting at, that's totally fine. But if you do start to completely stray away from what we originally discussed, if we talked about you were going to do circles and I approved that, and now all of a sudden you want to write about like Pop-Tarts, that's something that you and I would have to have a communication about, just because, again, the whole reason that I had you all tell me your note topics was to make sure that nobody kind of overlapped in an unreasonable manner. So I would just have to have that conversation with you to kind of reapprove your topic, just to make sure that it's still acceptable. So again, just reach out to me directly, and please do that in writing via email. That's always the easiest for me. And in terms of, where do I start now? So you should really be in the research stage, pretty much starting now if you haven't already begun. And if you're kind of asking yourself like, all right, how do I do that research? It can kind of seem like a bear at first. Here's just some tips that I put together. So certainly asking the law librarians for help, even if you don't even know where to start. They're able to really help you in a lot of ways that I think students don't utilize them for, but they can help you brainstorm. They can help you come up with ideas for search terms in Westlaw and in Lexis, and help you locate books and other sources that the library physically has, as well as on their databases that you'll be able to access as well. And I always say to begin looking into secondary sources. So if you see, I wrote Wikipedia tag. That's something that I did when I was in like middle school. We would say, okay, get from computer to pancake. And you would just start clicking on the little hyperlinks and trying to find ways to connect you to get from computer to pancake. And we always thought it was super fun, but I think it can really be beneficial when you're doing this kind of research too, when you of course, you won't necessarily be clicking on Wikipedia hyperlinks, but by looking at that secondary source and seeing the sources that they cite to, and then going to those sources, going to the sources that source cites to, can really kind of show you the progression of how you get from one point to another, because it helps you kind of see how another author was able to do it. So I hope that made sense. If not, you can ask me, but I think that that's kind of what I did for the bulk of my research when I was writing mine, was I really kind of utilized that tag. Another important things is, you probably already learned about this in legal methods, but utilizing Boolean search terms. So those are beyond just the normal, what is this authority? And that's using pluses and minuses and quotes. And there are explanations online for how to use Boolean search terms, and kind of gives you explanations on how to use those effectively. So that's something to keep in mind as well, just to help you kind of broaden your search if you're not getting exactly what you're looking for when you first start. Another big feature that I think a lot of people don't necessarily know about and or use is called Rabble View on Lexis. It's not available on Westlaw, only on Lexis. But you basically, you put in a case and then you click on Rabble View, and it actually shows you kind of like a web in different size font and different colors, depending on which stage of the law it's in, whether it's in the Supreme Court, an appellate court. And it also shows you how often it's been cited to. So you can kind of see what are the big cases in that regard that you can kind of utilize to your advantage as well. And just kind of a point of caution is just watch your use of other law review articles that have already been drafted and published by other people, whether on journal or in another publication. You're of course welcome and encouraged to look to them for guidance. But it's really important that you don't plagiarize, and plagiarize plagiarism can look really different depending on the situation, but it goes beyond just like stealing someone else's idea and presenting it as your own. But if you're really excessively pulling from someone else's work, that's considered plagiarism as too, and that's something that we certainly don't want to do. We are a prestigious publication and we want to remain that way. So it's really important to just, certainly pull from other sources and work that other folks have done, but make sure that you're honoring the fact that they did their own research and make sure that you're doing that own research as well.
Yeah, I want to make sure to jump in here. Everything Shira said, correct. I would also say, if you have no idea where to start, Google search your topic. It's fine to use blogs. Somebody might have just posted 1,000-word summary of your idea, your topic that might help you get started. Like Shira was saying, though, don't exactly copy somebody's idea. Also, do not, which we've seen in some articles that we are already publishing, if you see a blog that presents a lot of great sources, don't just take the sources and run with it and not cite that blog. If you find a good secondary source that points you in the right direction, make sure to credit it because you did use it. So everything you use, you cite. And it's fine. It doesn't make you look bad to use some blog or something as one citation. Just back it up with other authority. The more authority, the better. So just want to put that out there.
Thank you for that, Dan. And I think what he just said is really important. The more authority, the better. Just like we say when you guys are doing blue booking for the different, what are they called? The sub edits. And, we kind of say, there should be a footnote after every sentence. You have to remember that what you're submitting is akin to what we receive in terms of publications. So the same standards that we hold you to in terms of the sub edit is what we expect for all of you to do for this note and comment. So that may mean, of course, if you're having a true opinion, then you wouldn't need to cite it. But for the most part, that would be in a lot of your analysis situation, in your analysis section, which I will touch on in a moment. But really anything that is purporting to uphold like a law, or if you're talking about a case or another person's idea, then you would want to have a citation and a footnote, or if you utilize endnotes, an endnote after every single one of your legal propositions. So that's something to keep in mind as well. Think about the things that we talked about when we did our sub-edit training and different things that we had told you to look out for. Make sure that you're looking out for those same things as you're writing your note or your comment. And then I think one question that I've gotten a lot is kind of, what does the formatting look like for a case note or a comment? Because I think a lot of people don't necessarily have that familiarity because, you're used to writing your legal methods 1, 2, and soon legal methods 3 assignments, and it's very different. So this is the typical formatting of a case note or comment. And I called it the typical formatting because if you Google, how do I write a case note or comment? This is pretty much going to be what comes up. But I'll show you a little sample of what I did last year, just so you can kind of get a better understanding. You can choose to, if you want to write introduction, and that's a heading, and then your next heading is facts. That's fine, but you don't have to do that. This is just kind of the way that it's typically organized, but please know that it's honestly better to have more substantive headings because it's more fun for the reader and it allows you to have a lot of more intricate detailing that this wouldn't have. Dan, did you have something to say? It looked like you were preparing to speak.
When you're done, yes.
Go ahead.
Okay, no, I completely back that up. I have introduction in mind, and then I have more substance, and I'll send whoever wants it a copy of my note. This is just like Shira said, do not think you have to have everything here and just stick to that. Like, kind of arrange it how it comes to you. Use this as like an idea of how to start outlining, but as you go, you'll probably come up with a different structure, and that's fine. There is a section in the bylaws that shows you how to order your headings and how to format them. You have to stick to that, but other than that, you can name them whatever you'd like.
Yes, and Dan brings up a great point to utilize the bylaws, which you can find in the handbook, which is on TWEN, for any questions, because everything that is in the handbook is, of course, what we are bound by. So it talks in more depth than I'll be able to go over today. Some certain things such as like font, margins, things like that. I do have a slide about that in here, but it is really important to utilize the resources that you have as well, including the bylaws to help guide you. So I'm not going to go through all of these because I think they're pretty self-explanatory, but just the things that are typically included, you'll of course have a title page, which you can choose to have an abstract. Again, think about the things that you're looking for when you have, when you receive a sub-edit. And you can even use those to kind of, help guide you and see how they organize it to help give you ideas. Oftentimes they do have that title page with an abstract, which usually just kind of contains the overarching theme and the different, if there's, claims, if they're saying that, this is one way, but it should be another way, things like that. You should have a table of contents. I think that's pretty non-negotiable, because the writing requirement is 20 pages or more. It would be a lot easier for readers to have that table of contents. So I would say that's something that you definitely should have. An introduction, if you're doing a case note, then you would include something about the facts, the decision, but really the meat of your paper should be your analysis and looking at the different implications that it can have in the future. And you can also I cannot speak today. You can also rope that in with your conclusion and include any implications and your thoughts. And again, you do not, of course, need to cite to your own personal opinions and your personal views. But if you kind of formulated that view utilizing somebody else's work, make sure that you're citing to that as well. I always think it's better to oversight than to undercite because it's easy when you're going through the editing process to take things out, and then it is to kind of be adding them in at the end. Any questions so far? Great.
On that point of citing to your opinions, I would recommend that if you're arguing with someone, in my paper, I argue with a noted law professor. So every time I said something counter to what he said, I cited someone else as well, because I'm a law student. He's a law professor. I need some backup, right? So you don't have to, but it does make your argument more persuasive if you're pointing to something else that agrees with you or something else that backs it up. Not necessary, not plagiarism if you don't do it, but it can help, punch up your persuasion.
Absolutely. So I apologize. This is a little bit difficult to read. You don't need to read the substance of it. I was just trying to show you kind of how I organize mine. So in case you're not able to see it, on the left, I have what was my title page and my abstract. So you can see my title page. It was really just kind of one sentence, what I named my article. And then I had the abstract, which took up about a page. Right after that, I had the table of contents. And you can see the way that that's formatted, and that's pretty much how yours should be formatted as well. It's kind of, the standard typical. And then the third photo that you can see, that was where I kind of did my, like my intro, talking about what is cryptocurrency, because I've told all of you at this point, but I did my comment on cryptocurrency and the implications on antitrust law. So I really wanted to, make sure that prospective readers really understood what cryptocurrency was, because it's, it's, even if it is something that you think is super menial, if it's, if your thing is, what is the First Amendment? And you're like, oh, everyone knows what the First Amendment is. I think it's really important that you still have that background information, because A, not everyone knows what the First Amendment is, and B, they may have one understanding of it, but you want to make sure that they're kind of on the same ground as you in terms of what you mean by saying the First Amendment. So it's really important to kind of always make the reader aware of where it is that you're coming from, so that they can kind of all be on the same foundational basis. And I also included that third photo because you could kind of see the way that I organized my footnotes. So I utilized footnotes as opposed to endnotes. To me, I just think that it looks a little bit cleaner. And because we do utilize footnotes for all of the other articles that we publish, I think that just makes the most sense. But per the bylaws, you are able to use footnotes if that's what you'd prefer. I personally just like to use the footnotes better. And then I had, 20 plus pages in between. And then on the right, you can see that I had my conclusion. So I just did one paragraph, one full page. I called it conclusion. I probably could have made it something more fun, but that's what I decided to go with. Please note that you also need to utilize page numbering. So you can see that, in the bottom right of the conclusion, that was 23 pages. Not only does that make it easier for, if you are selected for publication, for readers to kind of keep track of things, and for the table of contents, but also it really helps out the executive board as well as our faculty advisor, Professor Regan, when we're going through and making sure that all of the requirements have been met in order to be in good standing as a journal member, because the requirement is 20 pages. If you have the number of pages already ready for us to go, then we don't have to go through and count them. So it makes our lives easier so that we're able to focus on the substance of your pieces as opposed to formatting issues. You'll also note that on the title page, I do not have my name anywhere. And per the bylaws, you will see that that is exactly how it's supposed to be. You are to put your first and last name on the final page. So in my case, it was the conclusion. You can see that in the photo all the way to the right. I have my name in the bottom left. And the reasoning for that is I'll talk a little bit about when I get to, how we select individuals for publication. But the reasoning for that is because I, as the internal managing editor, will go through and I will remove those names and randomize them so that nobody is aware really of who wrote what article other than myself, so that we try to keep things as non-biased as possible when we're selecting for publication. So that's something that's really important to make sure of only having your name on the last page. So I've talked a little bit about the requirements, but we're going to go a little bit more in depth here. So you have a minimum of 20 pages. Do not feel obligated to go over that amount, but also don't feel obligated to stay within that amount of pages. If you're really going really hard on your topic and you're finding a lot of interesting information and it becomes much longer than 20 pages, that's completely acceptable. It's not like in your legal methods class where they say, between 5 and 7, if you go above 7, I'm going to be pissed kind of thing. We're not like that at all. If you are, as long as it's really substantive and it's beneficial and providing more work that is effective for your topic, then we're more than happy to review it if it's more than 20 pages. It is typed in double space, and we do utilize Courier New font. So not Times New Roman, Calibri, anything like that. You have to use Courier New when you submit it. And then the typical 8.5 by 11 with 1-inch margins. And like I stated earlier, you're free to use footnotes or endnotes. We talked about only putting your name on the last page because I'm going to remove them and randomize them for grading. And just kind of a tips and tricks are make your own source comp as you're going along. If you want to highlight that information so that you can reference it later on, that's completely in your purview. But if you are published, then you will have to provide your own source compilation with, the same thing that you do for sub-edits with the PDFs. So if you're kind of saving the sources that you're utilizing as you go along, if you are selected for publication, you're going to thank yourself in the future. So while it is tedious, particularly when you're conducting research, it can save you a lot of time in the future. But again, that's entirely up to you how that you want to do that. You just do need to keep that in mind that if you are selected for publication, that is a requirement. I'm
going to step in there. That's slightly inaccurate. You need to keep track of your sources. You don't have to put them into a single file. Because my source comp would be over 1,700 pages, which just wouldn't work. Just keep a copy of every source you get and try to keep it foldered so you can refer to them later. Like Shira said, smart thing to do is highlight the passages, because if you're published, it'll happen next year. It won't happen this year. And you likely, like I have to, like Austin has to, you're going to need to go back and edit it a little bit because law changes, especially if you're doing an area that's like on the forefront. So that's where it's really going to come back into play, because you're going to want to site check. You're going to want to go back and make sure everything's accurate. If you're published and somebody contacts you, you're going to want to have this stuff so you can back up what you said. You're not going to have to turn that into anyone, but you need to have it for your own good. So keep the sources that you use, but you don't have to put them all into one file. I probably miscommunicated that to Shira. My fault.
Yes, you did.
I bet. That's why I clarified. I'm sure this is my fault. So that's why I clarified. You do not have to put it all into one file. Just keep all your sources.
All right. Thank you for that clarification. But one thing that I do know is true is that you will be editing and blue booking your own paper. Oops, excuse me. I can speak for myself and Dan, and most likely Austin as well, is that, we're more than happy to help the individuals who are selected for publication with their editing and blue booking to an extent. However, it is your responsibility, and that would just be out of the kindness of our hearts that we're doing that. So just keep in mind that that is something that will be the bulk of your responsibility. So don't wait until the last minute to do the editing and the blue booking, because those, again, are things that we take into consideration when we're selecting folks for publication is, the blue booking skills. So make sure that you are doing that as you go along.
Yeah, you do all your own editing and blue booking. Like I'm editing and blue booking my paper, Austin's editing and blue booking his. If you're selected for publication, we're happy, like Shira said, to give you some notes, but you're going to be published next year. We'll all be working full time, so I will not have time this time next year to go through your paper and give you a ton of substantive edits. So, get it right now, or at least get it pretty close to right.
Yes. And so I don't actually know the plural of pa, but do not make these faux pas plural. So a lot of people will kind of use unnecessarily superfluous language. So that's, I think we talk about this a lot in legal methods class. But sometimes people think that it makes you sound more intelligent to be using more words. And in some cases that might be a stylistic choice. But it's, at the end of the day, your reader is reading because they're interested in the substance of what your topic was. That's kind of what got them to open it in the first place. So make sure that you're kind of, spending those 20 pages plus focusing on the things that are really important and substantive, because again, that's going to help you be more likely to be published if you're, really getting to the bulk of the point. And it's super interesting in that you have 20 plus pages about that without having to kind of, go on a long spiel about things that aren't necessarily, relevant. The use of passive voice. I am a big component of this. I still do it, which is unfortunate. I'm actively trying to do better. That is something that we all need to work on, but certainly in a legal publication, that is something that you want to keep in mind. A lack of critical analysis. Some people, think it's more important to focus on, this is what the court did and this is what the court said. And that's great. We care about what the court did. We care about what the court said. But I want to hear about what you think and how this is going to impact the future and how this impacts Delaware corporate law or things like that, kind of making sure that that's really like the meat or the bulk of your note or comment is really on that critical analysis, because that's going to be what sets you apart from someone else who writes about it. Because yes, if you're writing about the EPA case and so are 3 other people at other publications, generally, the facts, the decision, all of that is going to be pretty similar in terms of what you write and what they write. But what really can set you apart is by having that critical analysis, because that's going to be something that's unique to you. Waiting until the last minute to start. And so I said, frankly, waiting until the last minute to edit. This is something that I encountered. I did not wait until the last minute to edit, but I kind of, told myself like, all right, the last week is going to really just be doing the polishing and everything. And you never know when you might get mono. And I got mono literally a couple of days before our note and comment was due last year. And I ended up not really being able to polish it as much as I would have liked to for that reason. So even though I hadn't waited until the last minute and I had kind of, told myself, all right, those next couple of days are just going to be for that one specific purpose, because I had waited until a couple of days before to leave that, I didn't really get to make as polished of a work product as I would have liked. So that's just something to keep in mind as well. Poor and or lazy blue booking. Again, we are members of the Delaware Journal of Corporate Law. You are expected to have great citation skills because we know that all of you are capable of them. That's why you're a member of the journal. So just, make sure that you're utilizing the blue book and not making silly mistakes like recalling particularly the 3-id rule, because you are trying to get published in the Delaware Journal of Corporate Law. And we do have that 3-id rule as opposed to the blue book 5-id rule. So just, keep in mind those things that we have you look for when you're completing sub edits. And another thing is just kind of like only pulling from one source type. You can have a successful paper if you're only pulling from books or from treatises, but I think what really sets papers apart is like you may have seen in the Barbie paper that y'all have been working on for the sub edit previously. They touched on cases and books that were in print and electronic books and different things from around the world, and it really kind of created a more holistic understanding of the topic, and I think it made it really interesting. So that's something to keep in mind as well.
I think these are all great points. Shira gave you more time this year than we had. Use it, but I would say try to have this finished before Thanksgiving. If you don't, you have Thanksgiving break, you have until December 6th, but like your finals are going to start and you just want to be done so you can get started on your finals. Also, if you set that goal and you don't make it, you haven't blown the deadline. You still have, runway left. As far as, having more sources, the better. Like I said earlier, you can start with blogs and articles, get some case law and some statutes if it applies. And don't use passive voice. One other tip that my 1L LM teacher taught me, you never have to say whether or not. Whether means whether or not. So you never have to add the or not. It's superfluous. You don't need it. So my tips and tricks done.
Thank you for that. So now, we've talked a lot about what the actual contents of the paper would look like, but I know everyone really cares about, who gets published, how we make that selection, how that works. So I'm going to talk a little bit about that. So as soon as everyone submits their papers, at that point in time, you no longer retain the rights to what you've submitted. It becomes the ownership rights of the Delaware Journal of Corporate Law during that review process. And basically that means that you're not allowed to submit your article to any other publisher or any other publication until you're told explicitly otherwise in writing by me. This is like a serious infraction because this is legal at this point, and it will not be tolerated in any capacity. I don't think the journal has ever encountered that issue, and I frankly don't want it to be the first time that we do. So just as soon as you hit send and that comes over to me, it's the property of the journal until you hear otherwise. Any questions about that? Okay. However, once you receive official word of the members who are being selected for publication, if you're not one of the individuals who is being published, then you are returned the rights to your paper and to everything included in it. And if you are selected for publication, you no longer own the rights to what you've written. Those are now the property of the Delaware Journal of Corporate Law. And you're not permitted to publish that piece anywhere else without express permission from the Delaware Journal of Corporate Law. And that permission would probably come from Professor Regan. That would kind of be in his purview. So that's just, again, we've never, to my knowledge, encountered an issue like this, but it's something really important to keep in mind. And that also goes for posting on LinkedIn. I know when people find out that they're getting published, they're like, oh, yes, this is great, incredible. I want to, post this on my LinkedIn. But until you're given the okay by the Delaware Journal of Corporate Law, whether that be the executive board or Professor Regan, you're not able to do so. That's, for a variety of legal reasons, but also we want to make sure that others don't have access to what we're publishing before our actual subscribers do. That's something that's really important, and that we take pride in allowing them to, have that access before others do. So keep that in mind. Any questions at all about any of the copywriting or anything like that?
Yeah, just to clarify, when you're talking about like LinkedIn posting, for instance, you're referring to posting the actual notes, not necessarily just commenting that you are being published.
That's
right?
correct. Yes.
Okay.
Yes. Yep. You are certainly allowed to tell the world that you are being published, just until you're given the okay to actually publish the actual article in any other capacity. That's what I'm referring to.
Okay, thank you.
When very soon we'll be publishing online the last 2 issues of last year's volume. Once your note, if you're published, hits the website, then you can just link it to your LinkedIn. That's fine because it's already up. That's probably the delineation. And the goal would be to have all ours up by this summer. Next year, it'll be up to your board, 49 board, to figure that out.
Yes. All right. Moving right along. So, how does the e-board select articles for publication? So again, we take into consideration a variety of different factors. Some of them being, the likelihood to be of interest to our subscribers. So, we'll look at our subscriber list and see if it's mainly, firms or different courts, specific individuals, and kind of determine, what would they be interested in? Of course, again, we are the Delaware Journal of Corporate Law. So that's kind of why I set that requirement that it has to be corporate adjacent what you're writing on. And if you're able to, include some kind of a connection or a strong connection even to the state of Delaware, that's of course going to help propel you in that regard. And then of course the quality of your work, whether or not you're able to, and I actually just said whether or not, which Dan just told us we don't need to do. That's funny. The quality of work, whether you can make a strong and a reasonable analysis, And when I say reasonable, that, sometimes people come with outlandish ideas, but as long as you can utilize different facts and sources to back up your claim, that's more than okay, as long as you can kind of show some kind of a reasonability in where you came to that conclusion. And again, always citing back to where you get your ideas from. And also kind of uniqueness and presence. So everyone has different writing styles, and we really kind of want to see, not just boring and just kind of like going through things. That's the whole point of the critical analysis, is to really allow your voice to shine through and to show us the writing that you're really capable of. And this is like, for I think most, if not all of you, this is your first chance at publishing something in a legal capacity. So keep that in mind, that this is an incredible opportunity that all of you are being afforded, also required to do, but afforded. So I really urge you to put in your best effort and really try to get published. So these are dates that I have to keep in mind and kind of help keep you on track. None of these are like deadlines, they're simply guidelines. The only deadline that I have is that your note is due December 6th. There will be no extensions, no excuses. I spoke with the registrar today to kind of talk about what that would look like. And we came to the agreement that there will not be any extensions barring, true emergent circumstances. But we'll talk more about that as we get closer to the final due date. But so I would suggest, starting now, really beginning your research, if you have not already, and start outlining and organizing your thoughts. I think by mid to early October, you should probably have a decent grip on, what your paper is going to look like and what things you really want to focus on, if there's any tangential points that you want to touch on as well. And by late October, at honestly the latest, I think that you should have started drafting the actual paper itself. I think even that's cutting it a little bit. I would probably try to do that more mid-October, so next month. But of course, the way in which you go about that is individual dependent. I have, peers who write fabulous papers within a couple of weeks, but then there are also other folks who, might need a couple of months in order to really gather their thoughts. So don't reinvent the wheel, the way that you work best. Think about, how you handled it in legal methods and if that was effective for you or not. If you need help kind of putting yourself on a schedule, if you're one of those people who kind of need something more rigid, I'm more than happy to work with each of you individually and help, kind of put you on a guided schedule. If that'll help you in any way, just communicate that to me individually. And then I think that by like early November, you should probably have at least a shell of what your analysis is going to look like. And when I say a shell, I mean kind of your first rough draft of what things are going to look like of your analysis section, because again, that's going to be the meat of your paper. So you kind of want to have an idea by early November of what that really is going to look like. Then by mid-November, I think you should really have everything that you're hoping to get across typed up and leave only the editing to remain. That gives you so much time to be able to edit, polish. You can even, take a couple of days or a week even and, look at your paper from a set of fresh eyes, because sometimes when you're so in the weeds in something, it's really easy to miss things that you wouldn't miss otherwise. So if you kind of take an opportunity to take a step back and then go back to it later, I think that's also a really good way to ensure that you're touching on everything that you're interested in touching on. And then I think the end of November / the first week of December, of course, prior to the 6th, should really be focusing on editing, proofreading, polishing, doing all of that. I don't think at that point you should really be working on anything substantive, because then you're more likely to miss things that you would have otherwise, and perhaps even have a sloppy work product, which I know none of you would like to have. And then again, the due date is December 6th. Any questions about that? Okay, so you might be kind of asking yourself like, all right, Shira, you just threw a lot of information at me. What do? I have questions. I don't even know where to start. So I think utilize your A-board mentors. They were given to you for a reason. All of the A-board members had to write our notes and comments last year. So everyone understands what it's like to be in your shoes right now and how, nerve-wracking, and it kind of seems like you're climbing a mountain right now. So utilize them to the best of your ability. I do just want to note that really the only e-board member that you should be asking for any kind of substantive help is me. And the reason for this is what I've already kind of went through when I was talking about selecting individuals for publication. But there's really no way for us to keep this, truly anonymous. But in order to maintain the integrity of the selection process, we want to make sure that kind of I'm already aware of everybody's topics because I'm the one who approved them. And that's kind of the whole reason that I, said like, don't tell Austin or Dan your topics if you're able to. It just kind of helps us to streamline the process and keep it as anonymous as possible. Again, this isn't a perfect system. And I hope that you all have like the trust and the faith in me to know that I will not abuse the power, and, will remove myself as nonpartisan as much as physically possible. Because again, Dan, myself, and Austin will grade the notes in the comments in conjunction with Professor Regan, and we are the ultimate decision makers for selections for publication. And again, we are bound to remain impartial to the best of our abilities. However, everybody has unintentional implicit biases. So we really want to keep that as much to a minimum as physically possible. So just try to limit your communication with the e-board in general about your topic, and utilize your A-board mentor before that. But if they're not able to answer your question, or if it's, something that they're, not really sure about, if they direct you to an e-board member, again, please just come to me directly. And if there's, an issue or a reason that it needs to go beyond me, then we'll certainly handle that on a case-by-case basis. But again, to maintain the integrity of the selection process, it's really important that you utilize your A-board mentors before you go to me.
If you're a superior author and you're watching this video, obviously I know your topic. There are several other people that I may know your topic, and that's fine. The key here is just do your best. If it happens, it happens. It's not this isn't legal methods. You're not getting kicked out of school. Just try to do your best not to like blab on your topic to me or Austin. I'm not going to. I'm probably, if I know your topic, I'm not going to be biased, but I expect all of you to try really hard. I'm not playing favorites. If you were my best friend, you would actually be held to a lot higher standards, because I'd be like, no way. But nobody likes me, so nobody has to worry about that. It's a joke. But yeah, just do your best. It's not you can talk to people like Shira said. If you want to talk to a professor, that's fine. Family members, whatever, just do your own writing. We're not going to be like hunting you down, trying to figure out but just don't plagiarize. This is your work. This is your chance to get like a piece of independent legal research. This gets your requirement for law school done, and it's something to carry with you and talk to people in the legal community with. So just do your best work.
Thank you for that, Dan. That is everything that I have in my presentation. So I'm happy to answer if anyone has any questions, or if you don't have any offhand, send me an email, shoot me a text, phone call, whatever works best. But for those who are on the call, are there any questions I can answer right now?
I have a question in regards to like collecting our sources for the note. So I know I'm PC, and we were working with the Foxit program and the free trial. Is there any word on, did we actually get the software for it now to use?
Yes. Great question. Rose purchased the software. She said she hasn't gotten the keys in yet, but I think she has to be on her computer at work at school to get them. So I'm meeting her on Monday, and hopefully at that point I will have them to distribute to you. Otherwise, just download PDFs individually right now, because that's been a real headache. Thank you for bearing with me on that. It has not been fun, but that problem should be over. PC team, go PC team.
Okay. My other question is in regards to like notes, like if you're doing a fairly new topic and you're trying to develop the research for it. And I noticed that for notes, because when I did the write-on, you guys did the case that we were supposed to do analysis for. Like, are we supposed to just pick a case that we feel is in a close relation to that topic and write on it? Or are we just using a case that just supports it?
That's where you get to be creative. And that's honestly, you're going to find that in the legal world. When you have an issue come towards you and there's no on-point case, you might have to cobble together like 3 or 4 cases, or like for this project, you can pull a law review article and maybe some argument that you see out in public, some debate, pull from a bunch of different sources. But yeah, you may have to, when you're on the forefront of these things, there may not be It's probably not going to be a Supreme Court case. There may not be any appellate opinions. You're going to have to be looking for stuff that maybe just is like around the edge of the issue and be like, well, this case said sort of this case said sort of this, and be creative. And it's fine to be like, I only find 2 or 3 cases that are related. That's fine. Then you get to make up your own analysis. That's don't feel bad if that's the case.
And also adding on to that, even if you do find a case that's directly on point, you're not bound by what that case says. You know, if you want to come up with an argument that, you know, that decision was wrong, obviously do that in a respectful manner. But, you know, if you can formulate an argument to state, you know, yes, that authority said that, however, this authority says otherwise. And then kind of like what Dan was talking about too, where if you're not able to find something directly on point there, you know, I think oftentimes you're never really going to find something that's directly on point, but if you can find something that's tangentially related and be able to kind of rope it in. So for example, if, I don't know, if you're writing an article about tiger bites and there's never been a case before about tiger bites, kind of, you know, finding cases that talk about zoology law and animal law and dog bites in the state of Delaware, whatever, what have you. If you're able to find things that are related and say, you know, though not specifically related to the case or to the incident that I'm referring to, you know, looking to the Third Circuit opinion in XYZ case, you know, we can pull this argument and apply it here. So you can kind of like pull from what other judges have said in other jurisdictions, if that's kind of what you're going for. So I do just want to like clarify, you don't have to make your paper surrounded by a case or surrounding a case. I think, you know, because it is a legal publication, you should have cases in there in some capacity, but that doesn't have to be the core, as long as you're able to formulate a legal argument using legal analyses. It doesn't have to be kind of about a case, if that makes sense.
It did. Thank you.
No
Mine was on a
problem.
federal statute, and then I sort of found a couple cases that applied it, but most of my actually comment, not note, is the effect of this federal statute and how it affected Delaware law, and then how it was carried out federally. So,
Any other immediate questions that we can take on?
I have a question. So while we're finding sources and getting a more and more compilation going, how would we have like an idea of when we found a sufficient amount? Like, is there like a, I don't know, for lack of better words, feeling that you're supposed to get, like where you feel like it's all finalized, or is it like something that you should always be constantly searching for sources? Like, how exactly would that go?
that's a great question. And if you come up with a definitive answer, I'd love to hear it. My take was things started referring. You sort of get this answer in legal methods. You sort of get this answer when you're working for anybody. When things start to point to each other, you've probably done a decent job. When you're on the edge of law, my thing, Federal Trade Secret Act, Defend the Trade Secret Act, it's pretty new. It was pretty harrowing because I couldn't find any appellate arguments, and I'm sitting here like I have it. There are no appellate decisions, and every day that I have that sentence in my paper, I'm checking Westlaw and Lexis like, please, like, don't let me turn this paper in and a Third Circuit decision have come out the day before and make me look like an absolute idiot. So it's tough. Just, you know, that's why I start now. Search for stuff, pull a bunch of different sources. You know, you can talk to us about this. Go to Shira first. If you hit a problem with research and like you're not getting anywhere, don't spin your wheels for too long before you reach out. Like, I mean, you hear when you work in firms, if you're looking up a topic and you spend like 2 hours and you're not finding anything, go ask for help. Yeah, like if you're not finding anything, reach out for help. And you can ask an A board member, ask Shira. If Shira doesn't have an answer, she'll come to me, pull me in, and we'll help you out. Don't spend weeks not finding anything. Reach out quickly, because this is not like some legal methods like let's go test them to see how they do. No, we just like, you have to do this as part of your school requirement. You have to do an independent writing project. You, as part of your journal membership, you have to do it. It takes care of that. And we want you to succeed. I mean, we would love to have the problem to have, you know, everybody submit a note. We're like, wow, yeah, we have to publish all of them. It costs us a little bit of money in publishing fees to put together a compilation that thick, but that's, you know, we'll hit that bridge when we come there. So just reach out. Don't worry about it. If you're having trouble, just reach out.
And I just want to add 2 points onto that. The first being that you'll all have expected to have read and abided by the bylaws, but it does say that you need to put in a good faith effort, and that is critical and crucial, particularly if you plan to receive a note credit. You need to put in that good faith effort, and we will be able to tell if it's not there. I don't anticipate on having that issue with any of you, or we would not have selected you to be members of the journal. But that's just something to keep in mind in order to meet that writing requirement for the school. And then kind of unrelated to that, it's actually funny, Dan was talking about, looking to see in Westlaw every day if there was any updates on the case. But something that you can kind of do to hopefully avoid having to do something like that, because I know some of you do have some really current topics that, there really is the potential that things are going to come out as you're writing. I know for a fact that Lexis does, and I believe Westlaw also has an alert feature where you can put in different search terms and different things to have it really send you like an email and, say like, oh, there's this new Third Circuit opinion related to XYZ thing that you put in. Of course, don't rely on that, but that's certainly kind of a way to also help you kind of keep on track if you think you're going to get, distracted in some capacity. If you kind of forget about it for a day or two and then you get an email about something, it'll, like, oh, right, working on a note. So that's something to keep in mind as well to be able to utilize. Anything else?
Right.
All right, hearing nothing, then we will adjourn this meeting. Again, I'm going to send out this recording to all of those who did attend and those who did not. If you have any other questions, please always reach out to me after reaching out to your A-board mentor if it's substantive, but if it's something that really isn't about, the meat of your paper, you can certainly come to myself, Dan, or Austin for that as well. And we look forward to, being able to help you all out to the best of our ability. And we really look forward to reading them starting on December 7th. All right, so at this time, I'm going to close out the meeting. Thank you all for attending, and I hope you have a great rest of your night.
Thank you, you too.
Thanks.
And you too, Dan.
Thank
and
you.
Jacob.